Good morning. Good morning and welcome to the 2023 Association of American Law Schools Annual Conference. It is truly terrific to be back together in person. My name is Erwin Chemerinsky. I'm Dean of the Law School at the University of California, Berkeley. And I have the great privilege this year of being the president of the Association of American Law Schools. We could not possibly have a better way to start our conference than hearing from someone who's truly a hero to so many of us, Justice Sonia Sotomayor. Everyone here is familiar with Justice Sotomayor's biography. She grew up in New York. She attended Princeton University, where she graduated summa cum laude. She went to Yale Law School, where she was on the Yale Law Journal. She was an assistant district attorney in New York and in private practice. And for the last 30 years, she's been a judge. First on the United States District Court for the Southern District of New York. Next on the United States Court of Appeals for the Second Circuit. And in 2009, President Barack Obama nominated her to be an Associate Justice of the United States Supreme Court. Just a couple of things about the format. One is, welcome the opportunity for you to ask questions. Because of the unusual nature of this format, we're going to need to do them in writing. So if you have a question to ask, if you could raise your hand, a member of the AALS staff will bring you a card, and then if you raise your hand, we'll collect the card. They will get them, we'll process them. Just because of the format, if you could put your questions in early, we'd be much more likely we'd be able to get to them. And also, no pictures, please. With that, Justice Sotomayor, thank you so very much for taking time from your incredibly busy schedule to talk to this conference of law professors. Let me start.
Erwin, I'm delighted to be with you, at least virtually. I am sorry that I can't be physically there, but you're a little bit far away from my DC home.
Well, we're just so thrilled that you're doing this. It's obviously been a momentous year in the United States Supreme Court. Let me just start by asking, how are you?
At this moment, I'm okay. And by that, I mean that I'm doing something I love, which is talking to engaged, committed people who are really interested in improving their craft and in reaching out and stimulating a love of law in students. So for me, these are always moments that give me hope. If you're asking how that momentous decision affected me, my word description would have varied from day to day. Sometimes I was shocked. Other times I was just deeply, deeply sad. And many times I did have a sense of despair about the direction my court was going. Yet the term started, and I realized that one doesn't have an option to fall prey to despair, that I have to get up and keep on fighting. And so at the moment, my deep sense of perseverance in life and ensuring that I try my hardest every day to do what's right continues to buoy me and keep me alive. And it keeps me going. And I assume that that's what a lot of people are feeling. It's never, one word doesn't describe the complex emotions that swirl after a year like last year.
I think hearing it from you is very important and very special to us. As you know, this is a conference of law professors. I can't resist beginning by asking, what was your law school experience like?
A lot different than what I think students experience today. First, I was privileged to be in an environment, my alma mater, Yale Law School. I know that many of them are going to get upset when I say this, but my professors at Yale were arrogant enough to believe that if they picked you to go to the law school, you had to be smart. And with that assumption, they treated you as an equal. And that was a terribly important experience for me, who had gone through traditional schooling my entire life and in college, where professors challenging you often made you feel like they were doing it to show the limitations of your thinking, rather than engaging in an exploration of how to expand your thinking. And that was a very positive experience for me. Back then, I don't have a sense that students were as breezily involved in so many activities as they are now. The clinical programs were much, much more limited, even at Yale. Now they're, I think, the largest part of almost every law school budget is devoted to clinical training, if I understand correctly. You notice I didn't mention law professor salaries. I won't go into that, but I worry sometimes that the countless hours that I spent talking to friends at law school, studying in the library at night, with breaking to get a cup of coffee somewhere or soda, and sitting around and batting around some of the topics that we had discussed in class, that some of that may be missing. I'm told by most students that it's not completely missing, but I do worry that they may have a busier existence in law school than I did. And I don't always know that that's to the positive. There is something to be said about the ability to study unharried and to think about things in ways, in a slower and more concentrated way than I fear they may have time to do now.
I agree with that observation, and I also agree with you that there's pluses to all the things they're doing, but minuses in the way that you describe. This is, I said, an audience of law professors. Key part of our job is legal scholarship, writing articles and books. What do you see as the effect of those articles and books with regard to the Supreme Court? Do you, as justices, pay much attention to scholarship? Are there specific kind of cases where you do?
Erwin, I think that each justice is very unique in their approach to legal scholarship, okay? We have at least, I think more than one, but one former academic, my colleague, Elena Kagan. And I think she probably does quite a bit of legal reading, if only because that was part of her occupation previously, and she continues it. As you may know, legal scholarship has had an influence in many cases before the court. Look at the independent state legislature theory. That was created by legal scholars or legal historians, however one wants to see it. And there are some of my colleagues, as you know, of particular schools of thought are very influenced by scholarship of certain kinds. I don't know that I can speak on behalf of all of my justices in terms of what's important to them. I know what's important to me. The more that I can, the more scholarship I read, analyzing a field of law that's not tied to a court case, but that's tied to general theories underneath a theory, and pointing out either the advantages of that approach or the disadvantages. That's the kind of scholarship I look to, just in terms of enjoying to read it. If we're talking about scholarship with respect to cases, very much for me, the scholarship that's most important is the one that's not mimicking the parties. That is so useless to me, and frankly, I can tell that pretty quickly. You start reading the introduction, you skim the table of contents, so you get a sense of what is being discussed, And often it feels like, well, this is a separate article to support a party who's coming before the court. That has very little value for someone like me. Um, Articles that can point to the risk that a court's decision might have in other areas of law, those are terrifically important to me. We don't always get that in case briefing. We don't get a pointing to other areas of law that have borrowed from something that's before the court and that we might affect negatively if we rule in a certain way. Anticipating that kind of thing is something that we often don't have time to do in preparing a case, and that many amicus briefs in cases before us miss. And so sometimes articles that do that can be very, very helpful. I don't mind articles that propose different ways of thinking of things. I sometimes look at them and they help broaden my understanding of the limits and strengths of existing theories. But I don't know that unless they're encompassed in the rulings below and in the current parties' briefs, that can help too much. It might help in my thinking of the issues that I might want to avoid the court getting into. And sometimes that's just as important.
Well, let me follow up by asking, you refer to amicus briefs. Another thing that law professors often do is write and sign on to amicus briefs for your court. How helpful are amicus briefs? Are there particular types of amicus briefs that are more likely to be useful and influential for you?
Today, given the composition of the court and the direction that it's been moving in its jurisprudence, historical amicus briefs are very important on both sides of the issue, but they certainly do help save us as judges and our law clerks a lot of time when we can get a more comprehensive look at historical practices and closer looks at the accuracy of how those practices, the content and accuracy of how that content has been presented. I think that probably today is the most important kinds of briefing that can assist. Depending on the issue, so for example, in patent cases, copyright and trademark cases, industrial practices, briefs are often very helpful just for us to get an understanding of the on-the-ground impact of a ruling by the court. And so those kinds of briefs in that kind of case is important. But in almost any case involving an industry or practice in which our ruling will have a significant effect, it's helpful to have those kinds of briefs. Parties are limited to their 50 pages and petitioner to their reply. And so a lot of that background information gets filled in by amicus briefs.
That's really helpful. Well, let me shift and ask about oral arguments. I have the sense that oral arguments have changed fairly recently in the court. They've certainly gotten longer. The oral arguments in the affirmative action cases were 5.5 hours. Do you think these are good changes? What do you think's caused this shift with regard to oral arguments?
Well, I would not have wanted to be the poor lawyers who followed the affirmative action case. 5.5 hours is tiring for anyone. And I have noticed that the longer the morning is, the less attention subsequent cases get. And I'm not quite sure, I shouldn't say attention, but there's generally one case that consumes the oxygen in the air and the other one where the questioning is less animated. I'm trying to find the right word, Erwin. And I don't know how to cure that. I think that some observers have written about and friends who have spoken to me who have thought the arguments had gone on too long and were too repetitive. And I guess when I'm in the middle of it, sometimes I feel that way. However, I know that in previous times that I walked away from oral argument not having important issues adequately addressed.
Mm-hmm.
And I have felt something was missing in terms of my understanding of the case and my ability to explore issues that to me were important. That doesn't happen now. And to the extent that that benefits the justices, it might make up for the fact, I think, that it might affect negatively the audience. I'm sure that if you ask some of my colleagues, they would say they're too long now. Others would say it's just right. I think some might say it's too short. I doubt that very much. However, I do think that there was a dramatic improvement. The change came about because of COVID and our audio hearings that occurred during the COVID time. Since we were on telephone, the chief couldn't see, or none of us could see, who wanted to talk or didn't want to talk. And so we had to find a way to ensure that that the questioning would happen in an organized way. And the thought was to do what we did, which was to start a round robin, starting with the chief and working down in descending order for a certain amount of time. And then having the chief ask at the end whether anybody had any follow-up questions. And that format was very structured, and it meant our arguments were more limited in time, but it took away the freedom of exploring between us or among us that happens when we have the open questioning rounds, where people can jump in and follow up on something that someone has said. And so the hybrid model that we have created, it was a product of COVID, and it was a product of the learning we did during that time. And I think, as I explained, that it has satisfied everyone. People who may have been reticent to ask questions previously feel more comfortable with the current structure where attention is given to each justice individually to ask the question he or she may want. And for those of us who like the open style better, we still have a large part of the argument that way. And so we were satisfied. So this hybrid was going to introduce longer arguments, but I think to good effect.
As someone who's argued several times before you in your court, I see both sides. On the one hand, as a lawyer, I so welcome the chance to have more questions. On the other hand, as a lawyer up there, there's a relief to know that in 30 minutes the red light is going to come on.
I have seen a note of relief with some people when we finally finish, okay? When the chief announces, or at least when the last questioner among the justices is finished.
I wanted to ask a follow-up. You referred to how oral arguments changed during COVID. I'd really be interested in hearing more about how the time of COVID affected you and how it affected the court's work.
How it affected me. Erwin, I think most people know that I'm a classic extrovert. I love people. And one of the things that's missing from this exchange is that I'm here talking with you, but I'm not walking around the room and hugging old friends and shaking hands with new ones. And I miss that. And I think everyone who knows me feared that COVID would have a deleterious effect on me, that the withdrawal from people would somehow sadden me or depress me. Nothing was further from the truth. COVID put a pause on my overly hectic life. As you may know, pre-COVID, I was one of two justices who generally, I competed with Justice Scalia only in how many speaking engagements we had. And that was because I enjoyed them. and I enjoyed the interactions with people. But my life was overly hectic. I was running a pace that long term probably was not going to be healthy for anybody. And so there was a pause moment in which I got to just slow my life down and think about the things that I thought were important in life, and to start thinking more about prioritizing my relationship with people I loved, including my own mother. As you may know, she failed during COVID. And I'm eternally grateful because of the audio sessions in court. I was able to spend time with her in her final months. I wouldn't have been able to do that even now, even post COVID, that I'm slowly re entering the world. I am doing it more slowly, trying to find a greater balance in my life. And so, look, I lost many people during COVID, some to COVID, others to other conditions. There is something precious about life that sometimes we forget in the hustle and hustle of our everyday living. And COVID gave me a time to think about that and to learn how to keep it present in my life. As for the court, in some ways, I think it made us appreciate the things that we do together. The first thing that came back in person was our conferences. And we had been doing those by telephone initially. And the second term, we began at the end of it to do the conferences in person. And there was, I think most of us had a sense that our personal interactions are important, whether it's walking out of conference or out of the court and people continuing to talk as they walk down the hall about something that was on their mind, whether it's on a break, coffee break during a conference, where 2 or 3 justices will go into a corner and mention something that might be troubling them. Those human interactions are important to maintaining relationships and sustaining them. And so I think the court understood that those were valuable things that we did, that were meaningful, and we shouldn't be thinking about ways of substituting them. We have had during, as you know, some of our court appearances to this day, some justices that have been ill and have attended by telephone, and we've done that too for conferences. Those are helpful. I think that there have been more than one occasion when a justice has physically appeared in court where they maybe shouldn't have, only because they were ill enough not to have done it if they could have avoided it. Myself included, the morning I broke my shoulder and came into argument and then went to see the doctor. I think I would have preferred to have been home or at my office doing that oral argument and then seeing the doctor. Anyway, we have done more with electronic filing. We have done more, I think, with lawyers who practice before the court in terms of reaching out to us in writing rather than having to call the court. So as with the entire court system across the country and in the States, COVID introduced more access to technology that I think has helped the courts generally.
Thank you. Thank you for that detailed answer. One of the questions that's come from the audience is a follow-up with regard to oral arguments, and I'll read it. You become known for your dissents. What advice would you have for lawyers who know they are arguing the more challenging, perhaps hopeless side of a case?
One of my favorite books in life is Don Quixote. And because I tilted windmills constantly, you know that from my dissents, okay? And this question wasn't asked, but I will fold it in, Erwin. I often, every time I sit down to write a dissent, the first question I ask is, what's the purpose of this dissent? Who's my audience? And what is it that I'm trying to accomplish by writing and reaching out to that audience? And you say, well, what audiences are you talking about, Justice? And there's a multitude of audiences that a Supreme Court decision reaches. You start first with the lower courts, whether it's a circuit court or a district court. Sometimes the audience is different because sometimes we're writing about things that affect district court's discretion, and you're trying to point out to district courts that there may be different ways to look at and think about a problem than they have been so far. Sometimes it's the circuit courts on issues that haven't been reached yet and or are being reached by them, where they have their own balancing discretion, and you want to influence their thinking about that. Obviously, sometimes the audience is Congress, and you want to point out the unintended or maybe the intended consequences of a decision that one feels may or may not be what Congress might intend or want. Sometimes it's the executive branch. I've written dissents where there's a discretionary decision before the executive branch or an agency of the executive branch, and where they could change the court's ruling by taking further action. And sometimes you're thinking about them as the audience, about different ways for them to look at this particular problem and act on it. Sometimes it's state legislatures, sometimes it's state executive officers, sometimes it's the public, where you want them to be thinking more deeply about a problem and about their power to change laws and to take action to resolve issues in different ways than the court has. So I start that way when I'm thinking about dissents, because if I can't answer that first question in a way that satisfies me, that makes me realize that I do have something to add to people's thinking or to that audience's thinking, then I might not write a dissent. You know, cert pools are filled with injustices. And I can't physically write on every one of them that comes through the cert pool. It's filled with legal errors that get forgiven under the harmless error standard or the EPA due deference standards. And so you can't write on everything. And so I have to think about what my purpose both there and in a majority opinion before I go ahead and put paper to pen. But I think that question and the way I laid it out for you is really what you have to be thinking about when you're arguing a losing or difficult case. I shouldn't use the word losing, right? Not emotionally correct. But whenever you take up a cause, you should have a purpose for that action. Not merely representing a client, but thinking about what it is and who you want to influence. If you can't influence judges, what arguments do you want the judges to hear and write about? Because it will have an impact on something that's important. And so I guess that's the only advice I can give, which is that's what you need to think about. But there's one last thing that I don't want anyone to forget, and I spoke about this not so long ago elsewhere. We as lawyers, you as lawyers, have to recognize that in the end, sometimes the only thing you can do is to give voice to the injuries of the party you represent. And even when they lose, that they had someone standing beside them, helping them in that fight, is the only satisfaction you can come away with, but it is a satisfaction that is so totally important. Fighting alone is never something anyone wants to do. Having a lawyer who believes in your cause and will get up and speak for you is what the justice system is about. And so, yes, tilting at windmills has value.
I'm not sure that you can see the audience. It's a very large room, and it's completely packed. And I hope you could hear the rousing applause for that answer.
Thank you all.
Let me ask as a follow-up, as you were talking about choosing when to write a dissent, makes me think of how being a Supreme Court justice must be so very different from being a Court of Appeal judge or a district court judge, which you'd done previously. What most surprised you in coming on to the Supreme Court, and what's the learning curve like for a Supreme Court justice?
Chief, I'm going to start at the end, and then I'm going to come back to the beginning, okay? Chief Justice Rehnquist believed that no one became a judge in anything less than 5 years. If I understand his protocols correctly when he was alive and chief, he never appointed a judge to do any committee work on behalf of the Judicial Conference if they had served for less than 5 years. He believed that you need that span of time to understand your craft, learn how to do it in a more efficient way, and learn how to balance all of the competing needs that are attendant to being a judge. Whether it's learning how to write more effectively, figuring out your role in that judicial process, understanding the people you work with and how to accommodate their needs with your own, all of that takes time. And so for me, I would say that it did very much take 5 years. I remember talking to Steve Breyer at the end of my first year and conveying to him in a dinner conversation with him and his wife how I didn't know what my role was on the court. Why me? Why was I picked for this? And subsequently, almost 2.5 years later, I had that talk with David Souter, my predecessor on the court. We were having lunch together one day in Boston, and I was describing my feelings, and both of them relayed the same thing to me, which is that that's a feeling every new justice has, that over time you grow into what your role is in this larger group of people. And I know it took me about 5 years, Erwin. I think my writing became stronger over that. I was much more a lawyer's judge when I started. And I think over time, I am still a lawyer's judge because I still do a lot of legal analysis in my decisions, but I've learned to overlay them with more observation and discussion of the human consequences of things. And so that period takes time, and it takes learning from your colleagues about how to do things better. And as I explained earlier, learning them and how to work with them. Going to the first part of your question, I had not appreciated as a district court judge or as a circuit court judge how much solace I took in knowing that I was not the final decision maker. That I knew that if I made a gross error of some kind, that there would be a court above me to correct it. I learned over time as a judge the arrogance of being in any occupation, which is sometimes they got it wrong too. But there was a solace that I wasn't the last word. When I got to the Supreme Court, I didn't realize how heavy a burden that is. And it doesn't matter how big or seemingly consequential a decision might be to the parties and to the world. Even the small cases before the Supreme Court have huge consequences. And that makes the job harder. It also has surprised me how virtually every case before the court is a gray area case. When I was on the district court, I dealt with hundreds, if not thousands, of matters in a year. And if 1% of those matters were things that reached the Supreme Court, that was a lot. Most of the cases were routine, not routine, but applications of established principles to facts that might be a little different than what came before, but certainly within the, not quite the gray area, but the blackish area of the line. When you got onto the Court of Appeals, 10% were the cases that were really new and groundbreaking. On the Second Circuit, if we heard 36 arguments a month that I sat, 30 of them were resolved by summary order. Maybe 6 of them required writings. That statistic changes dramatically when you're on the Supreme Court. 100% of the cases are gray area cases. And every one of them is hard. Even when you join a majority, you know that there are counter arguments that should and have given you pause. There is no decision we make that's black and white. We write as if it's black and white. You know, I often will tell people, you have to read the dissents, because if you read the majority, you think, what's wrong with the other side? Are they just crazy? But once you read the dissent, you know there's always counter arguments. And it's surprising how many cases are close, even when the court is unanimous. Sometimes we know if it's a statutory question that we just have to give an answer. But often in those cases, the pulls in two directions are very strong. And you know, you can see a little bit of more of the tension in the bigger 5-4 decisions, but that gray area looms so large, and it makes decision-making so hard. Much, much harder than anything I faced as a judge before.
Having argued several cases and lost 9-0, that's really reassuring to hear.
You should be reassured by that.
You mentioned, of course, your colleague, Stephen Breyer. You mentioned your predecessor, David Souter. I think there's always interest in hearing about the relationship among the justices. One of the questions from the audience was, can you share a memory about your colleague, Ruth Bader Ginsburg?
Oh, there's so many involving her. I'll share a couple, okay? 2 or 3. Couple means 2, but up to 3. The first is, there's a protocol on the Supreme Court that when someone is nominated, you don't reach out to them until the Senate has confirmed. The protocol was born from the fact that many of you, as you may realize, people who are nominated aren't always actually confirmed. And so typically the day of the Senate hearing, the new justice will receive calls from all of her new colleagues, but not before that. Clearly, that's different if you know someone who's been nominated. You might send something, you might say something privately to them. But I didn't have a friendship relationship with any of the justices when I was nominated. The only one to send me a note was Ruth Bader Ginsburg. And she sent it through a marshal who, from New York, who had been with her at an event. And it was a little box with a collar in it and a note that said, Sonia, I hope you have use for this sometime soon. That clearly was a very special, touching thing for me to have received that from her. The next favorite moment of mine was at the induction of Elena Kagan, Justice Kagan. The president usually comes to our robing room to meet with us and greet us and see the new justice being sworn in later or shortly thereafter. And President Obama was there, and he said hello to Elena Kagan and then me, and then he turned to give a kiss to Justice Ginsburg, and he said to her, Justice, do you like that I brought you two sisters? And she said, I'm very happy you brought me two sisters, but I'll be even happier when we're 9 sisters. And that, to me, was a very funny retort, and one that I have repeated often. And I guess my third favorite memory, and I have so many more, Erwin, but these are the 3 that are really special to me. We were either at conference or in the lunchroom one day. We were together as a group, and we began talking about the contentious times that that colleagues had lived through in previous eras, when personal relationships were openly strained. And one of my colleagues said something like, I wonder when and why that changed. When and why did that happen? And a bunch of them were attributing the change to the open hostility, to this chief judge or that chief judge. And Ruth, very quietly in her corner, said, no, it's when women came to the court. And I stopped and thought about it, and have thought about it since she said it. And I realized that many of you may not know that she and Sandra Day O'Connors were truly sisters. They had T-shirts that they wore. One of them, one set of T-shirts said, pointed an arrow that way and said, she's Sandra, and the other one said, she's Ruth, because people confuse them all the time. But they were very close. And what I know from the lore of the court is that Sandra made it one of her missions to ensure that the lunches after conference and after oral argument were revitalized and that everyone attended. I am told by friends on the court that if you missed 1 or 2 lunches, you would find her sitting in front of your chair at some point saying, why are you missing lunch? Whatever excuse she would give, she would say, that's not acceptable. And she would grab you by the arm, walk you out of the office and tell your assistant, cancel that other lunch appointment. She's coming to the judges. Those small things by Sandra turned into big things. They used to watch Westerns in the conference area downstairs, in the theater area that we have in the Supreme Court. She would borrow movies from the Library of Congress. And occasionally the justice would get the justices together to watch a Western, which was her favorite. Those moments are important bonding moments, but important moments to the collegiality of the court. And so those relationships were built, I think Ruth was right, not just by Sandra, but by Sandra and her. That sense of friendship, even with people who were diametrically opposed to you in judicial philosophy, like her famous relationship with Nino Scalia, those were precious, precious lessons. And lessons that I think justices, since she has left us, but since others have left, have continued on the court.
Thank you so much for sharing those memories. I want to ask you a harder question. This is my 43rd year as a law professor teaching constitutional law. I've never seen some of my students as discouraged they are now about the Supreme Court and the Constitution. I start constitutional law with them on Monday. Do you have any thoughts about what I should share with them? What gives you hope looking to the future?
The fight. You're going to become a lawyer, I hope, because you believe in the good things law does. And the fundamental thing to me always about law is that it helps us as a society in our relationship with one another. Legal battles are fought between people and institutions, between people and their employer, among neighbors, among family members, among everyone and every part of this society. Law is attempting to help us in those relationships. It helps define our rights and responsibilities, our obligations, our sense of commitment to things, and when we can back out of them and when we can't, and when we should pay for them or not pay for them, what rights we have among and with each other. As lawyers, we are helping people's relationships. And ultimately, the Constitution sets the framework for our government's functioning in interacting among its institutions, the three branches of the government, but also with the people. And to the extent that as lawyers throughout history, we have helped change those institutions to make them better and more responsive to people. Whether it's the development in product liability law, whether it's our continuing efforts in environmental law, whether it's our various civil rights laws, it has been lawyers who have mounted and helped organize people in expressing their needs and enforcing the society to be more responsive to those needs. And people have given their lives for our civil rights. We cannot forget the many people who were killed during the civil rights movement, or beaten, the people who sat in lunch counters who were beaten because they had the temerity to believe that equality was a fundamental principle in our Constitution. If others could give their lives for us, we don't have a right to despair. We don't have a right to walk away in this fight. We have an obligation to continue it. As you know, I haven't tended to agree with the direction my court is going on it in many issues, and I will continue to voice that disagreement. But we need the lawyers to continue mounting those fights and to mounting the individual cases, or to defending the individual cases, seeking to have justice done in the right way. We need law professors to write about the ways the court has gone wrong. And if we do something right, please say so. But I think if you're a law student, if you're a law professor, you can't take wrong directions as permanent. I keep repeating the saying, the arc of the universe does bend towards justice. And I truly believe that. I also know that that arc can take a very, very long time. From our decision in Dred Scott in the 1850s to our decision in Brown versus Board of Education, it was 100 years. And it was a lot of hardship, even by Dred Scott, who didn't win. But he did end up dying a free man because the people, the son of his original owner, helped him buy his freedom. Wasn't a court case that gave it to him, though. And that freedom wouldn't come till 100 years later. May take us time, but I do believe we'll go back on the right track.
I hope again you could hear the resounding applause to your answer. And I think your answer is so important for us as law professors as we, next week and the week after, begin teaching our students again and trying to convey the hope that you've just expressed to us. We have only a few more minutes together, and I got a lot of questions. Let me just try to ask a couple of them. One of them that I received was, you mentioned putting pen to paper when composing a decision. Would you mind sharing your process? How do you even begin? Do you have any routines? Superstitions?
Well, writing starts with research. And so you start thinking about a case the minute you read the briefs. And I read the briefs before my law clerks do, generally. And there have been times where I've been busy in other things and we're reading simultaneously, or I'm reading it shortly after they have. But I never read bench memo from my law clerk without having read the briefs myself and the decision below, or decisions below. That process already starts me thinking about what an answer to the legal question might be. After argument and I'm thinking about my vote, there is always, and this is prepared generally by my law clerks after a discussion with me, about what's convinced me to vote a certain way. And they'll write up for me a statement for conference. And that statement for conference is not a long outline. It's generally just a page or two double-spaced. But it's really, what are the important points that have convinced me that this is the answer? And that's already starting the writing process, as you may well know, Erwin. I often don't write anything, whether it's a speech or a letter or something. Again, the first question is, what's the purpose? And my second question is, what is the theme that I'm trying to develop? And that theme, especially for example, for a speech, what's the sort of analogy? What's the story that I'm going to tell? What am I going to draw on to make my points? And that is sort of the central part of always my writing. You will always see a structure in my writing. And because it's based on those two thinking processes. Often then, I've had discussions with my law clerk, not just after in reaching oral argument and the questions I'm going to ask that reflect what's troubling me or reflects what I'm thinking about. Then we have conference among the justices. And the justices are all saying the things that have convinced them to vote one way or another. And then we wait to see if we get a writing assignment. And if I get the writing assignment, often, not always, but often the outline of the points I want to make are fairly self-evident. In the more complicated decisions, law clerks will give me outlines of how they think the decision should write. And from that outline, I might say to them, we need to emphasize this more. This I'm not sold by. That we need to express in a different way. These are the issues that I want to interweave in. And that outline then becomes their draft to me. Once I get their draft, then it's like heavy editing. Is it structured in the most convincing way? Are there arguments that that they're proposing that I don't agree with? Are there counters in what was argued in the briefs and that I heard in oral argument or at conference that I think we need to interweave more into the decision? There is that process of going back and forth and tightening the decision so it not only answers the question presented, but responds to every counter argument that was raised by I shouldn't say every, but the most important counter arguments raised by the opposition. The process is one of collaborative effort. I work with one law clerk on the original drafts, but all my law clerks are looking at those drafts too. As I tell them, anything that comes out of my chambers is our collective work. I want this to be the most understood, the clearest, most clearly written decision that I can produce as a chambers. And so for me, it is a process that requires editing. As I tell people, there are no natural writers. What there are writers who have learned their skill and know how to edit.
Again, I hope you can hear the applause. All too soon, our hour together has come to an end. Thank you again for being with us, for your candor in this discussion. Thank you for your passion and your compassion. Thank you for fighting for justice and for today inspiring all of us to fight for justice. Thank you so very, very much.
Thank you, Erwin. I'm sorry I'm not there, but hello to all my old friends in the audience.